All right, it's 12 o'clock. We are going to go ahead and get started. Welcome to part 3 of our tax increment financing workshop series. Today we are fortunate to have Mr. David Levy, who is an attorney at Baird Home, do a presentation on the legal perspective of tax increment financing. Before we get started, just a little housekeeping. If you can go ahead and make sure that you are muted, just so we can make sure that the presenter is not distracted during his presentation, that would be great. We do want to make this as interactive as possible. So if you do have questions throughout David's presentation, feel free to drop that in the chat. I will be monitoring it, so we will ask questions throughout the presentation. If not, I would encourage you to unmute yourself at the end of his presentation to ask questions directly. So with that, David, I'm going to go ahead and turn it over to you.
All right, sounds good. Thank you, Kelly, and thank you for having me. I appreciate the opportunity. And I want to reiterate what Kelly said. Please, I want to make this interactive. Much rather have you get your questions answered than have you spend your lunch hour listening to me talk and go through a PowerPoint. So please jump in at any time, either verbally or in the chat. And Kelly, thank you for monitoring that. I'm not capable of doing that as well as speaking, I don't think. So appreciate that help. And with that, let's jump right in. If you would go to the next slide. All right, thank you. So I thought we ought to start. I think everybody on the call probably has this basic understanding of TIF, but it never hurts to kind of remind ourselves. TIF stands for tax increment financing, of course. And if you think about the middle word or the first and the second word, tax increment, TIF is a way to finance public improvements or improvements with some type of public benefit or connection through incremental taxes that are generated by incremental or additional valuation on real estate that occurs when a developer or a city improves that real estate. So the value of the real estate goes up with the improvement. The incremental value, not the original value, the incremental value, which is the blue chart or blue part on this chart. The original value is the green part. The blue is the tax that comes from that incremental value, and that tax can be divided off from the tax that the original pre-project value generated, and that incremental tax revenue from that incremental value then helps pay for those improvements that are public or have a public benefit or a public connection. As you can see here, a couple of things that are, I think, important, and you hear people who either don't understand TIF or don't like it talk about a couple of things throughout the TIF term, usually 15 years, sometimes 20 years now. The developer or property owner is paying his or her property taxes throughout. So it is not property tax abatement. Essentially what the developer is doing is paying those property taxes as a means to pay off some financial instrument that monetizes the revenue stream from that incremental tax revenue. As you can also see there at the end of the TIF period, which in this chart is 15 years, but is often less than 15 years. Whenever the indebtedness is paid off, the TIF revenues go back to the taxing entities, including the incremental revenues. And as you can see by the big green part on the right side of the chart, from then on, those taxing entities that may have foregone some revenue for that TIF period receive all of that revenue then and in the future. Let's go to the next slide, please. Kelly forwarded me some questions that must have come up from a prior one of these. And again, I'm always a fan of trying to get people the information they're looking for. And so I copied and pasted these essentially into this slide. They're a little bit cryptic in some cases. And so the first one is writing ordinances and amendments. And if the person who has had that question is on and wants to expand on that question, that would be great. Otherwise, I can offer a few very general pointers on that topic. But any chance the person who had that question previously is on and wants to elaborate? Doesn't sound like it. Okay. A couple of points about writing ordinances and amendments generally. Follow the statute first and foremost. I know that sounds obvious, but even though it may not be a model of drafting or the most beautiful thing ever drafted, it's difficult for a court to set aside an ordinance that sort of goes check by check through the statute. So always follow the statute. Have your city attorney, of course, or an attorney familiar with TIF, review those things if ever possible. And ordinance and resolution really is what I'm talking about. The statutes in some cases allow or require things to be done by resolution. And in some cases, they require things to be done by ordinances. So again, you want to follow the statutes in that regard. Amendments, I'm guessing is referring to a redevelopment plan or maybe a blight study. Those are things that there are consultants around the state who are very good at doing and can do for you, usually at a fairly reasonable price. And so again, follow the statute and seek out expert advice as the best are the best tips I can give you in those respects. We're always happy to answer a question here or there as well. We get calls from cities who we may not represent in a formal fashion, but we do. We're always happy to answer questions, just kind of like we're doing today. The next, who has effective oversight of TIF projects, the state auditor or the state attorney general? It's a good question. And the first answer actually is your city attorney and your planning commission and your city council, and your community redevelopment authority or community development agency. If you have one in place, those are the entities and the people who are implementing your TIF program. And really they first and foremost by far have oversight over your TIF projects. The state auditor does review TIF projects. They review data provided to the property tax administrator in the Department of Revenue. And so at some level, the state auditor does certainly have oversight of TIF projects, as I suppose does the state attorney general as the attorney for the state, including the attorney for the state auditor. If there was a situation where the auditor thought that there was a violation of law that was significant enough or severe enough to involve the attorney general, they could. But quite frankly, if you're operating a TIF program in a city, one of the things that I suggest you think about is every time you make a decision about how to proceed, as part of that decision, think about, well, I don't want to end up on the front page of the local newspaper. I don't want to end up on the desk of the state auditor, and I certainly don't want to end up on the desk of the state attorney general. And if you live by those three principles, you should be in good shape. The third item that somebody mentioned was the requirements for micro TIF, and I've got some slides on that here in a bit, so I'll defer that one to those slides, and we can talk about micro TIF a little bit more in detail. Next slide, please. Basic understanding of the policies. Again, that's a hard one to kind of interpret without more. So I would ask if somebody, whoever asked that question or had that thought is on and is willing to speak up and elaborate on your question, please do. All right, hearing none, I'm guessing the person's not on or not coming forward. Excuse me. That's a hard one to respond to. There are a number of good conferences and opportunities for things like that around the state, and I suppose that's the best pointer I can give there. The Nebraska Planning and Zoning Association has their conference every year. It was just 2 weeks ago in Kearney. And actually that conference is going back to a spring cycle. So the next conference is in early March, I believe, like the 6th, 7th, and 8th. And I believe also in Kearney. I know I've spoken on TIF there, and also at a conference put on by the Nebraska Economic Developers Association. That's another good source of information and conferences, and then things like this that Send is putting on this afternoon. The next item, discussion of maximum leverage of potential servicing revenues, since the developer ultimately has the financial risk, but leveraging the tax exempt interest rate to maximum potential. So as I mentioned before, what TIF gives to the developer is, and it doesn't always have to be the developer, by the way, the city can also use the TIF revenues to do public improvements, but for the sake of this discussion, we'll assume it's the private developer. And again, the TIF revenues are the annual or actually semi-annual revenues that result from
yes, could I speak to someone about our insurance number? They had called wanting our insurance number, but I have since got a document from our insurance carrier that they approved my son's admission there. So I'm not sure if things just crossed in the mail or
I'm not sure you're on the right.
I can't remember her name.
Oh, I think somebody needs to go on mute. Whoever's speaking. Okay, we'll keep going. So the TIF revenues are a stream of income. The revenues don't happen right at the beginning. They happen twice a year when the developer pays his or her property taxes. As I mentioned before, TIF is not property tax abatement. The developer still pays the property taxes, and those are received by the county twice a year, and then the county distributes the incremental revenues to the city typically, and the city then distributes those revenues to the developer. So in a 15-year TIF, there are 30 payments of revenues if the TIF goes the full 15 years over those 15 years. But when you're doing a development project, you need the money up front. You have to build the infrastructure, whatever it might be, at the beginning of the project. And so you need to monetize that revenue stream. And there are a few different ways to monetize that revenue stream, like monetizing any revenue stream, borrowing essentially. There's a cost, and that's interest. Interest is the cost of borrowing money. And so there are a few different ways that different jurisdictions and different entities monetize TIF. One common, really ubiquitous in Omaha and used in some other places is that the developer goes to their bank, they get a loan from the bank for the expected total sum of those revenues less the interest, and then they assign the right to receive those revenues to the bank. So when that developer pays his or her property taxes each time, the part of those property taxes that are attributable to that incremental value that the developer created in the beginning go essentially to pay off that loan. In that case, because that's a private loan, that interest is not tax exempt, and so it's at a higher rate because the bank is going to pay tax on the income that interest represents. This question brings up a couple of things. One is the developer having the financial risk, and one is leveraging the tax exempt interest rate to maximum potential. I'll continue on with what I was saying before and answer kind of the second one. It assumes that the TIF revenues are secured by a tax exempt bond that a city would issue. I am not a bond lawyer, and you want to be very careful with tax exempt bonds. Most TIF bonds are not tax exempt, but it is possible, working with your bond counsel and your city attorney, to issue such a type of bond. Everything involved in that situation probably would have to be public. So the infrastructure would have to be truly, truly public infrastructure. It couldn't be, for example, the improvement of a historic facade, which some cities allow as a TIF eligible expense. It would have to be, streets and sewers and things like that. So it's difficult to leverage the tax exempt interest with TIF, with a TIF bond, but it may be possible in some cases. But it is only in that alternate structure where the city issues a bond, and then that bond is sold. The proceeds of that sale go to the developer as the way to monetize the revenue stream. And then as the developer pays his or her property taxes, those property taxes go to pay off the bond. And certainly if you can qualify that as a tax exempt bond and get a better interest rate, that's a great thing to do. This question brings up a second point, which I think is a really important point, sort of as a statement, which is that the developer ultimately has the financial risk. And so this again assumes that this is a private developer doing the TIF project. And the way the developer has the risk is not necessarily inherent. And that's why this is such an important thing that this person brought up. I'm glad they did. That developer's risk, or the developer holding all of the risk, comes about or is best and properly and importantly documented in the redevelopment agreement. So the TIF process starts with a blight and substandard study and designation. Then there's a redevelopment plan, which essentially says, here's the plan for redevelopment of the blighted area or a subset of that area. And here's how we plan to use TIF to do that. And then the third step is the redevelopment agreement, which is typically when a private developer is involved, is a contract between the city and the developer, which basically says, okay, developer, you will do X, Y, and Z. You will build this building to substantially do these specifications. You will put in this infrastructure and you will do these things within this time period. And we, city, will pass through to you the revenues, whatever revenues might be, that your improvements create. Part of that agreement should have two things. One, that the developer cannot protest his or her taxes below the estimated value of the original property plus the improvements. If they go and protest that down, you're going to be short of revenues. And so you want to prohibit in that agreement the developer from doing that. And sometimes you even see a developer try and protest their taxes up, which is a great way to confuse your Board of Equalization. But what they're trying to do is get the tax amount high enough so that the TIF note or the TIF bond will pay off. The other critical piece of that agreement is that if there is a shortfall in the revenues, so let's say we estimated that there was going to be $1.2 million in revenues, and so the TIF note or the TIF bond is for $1 million. And it turns out we come to year 15 and the incremental taxes have only generated $900,000. So there's $100,000 shortfall in that redevelopment agreement. You want it to be eminently clear that the developer and the developer alone is responsible for any shortfall. So that in my example, if you had that shortfall of that $100,000, you don't have the developer coming and saying, well, wait, my TIF note is due. City, somehow this was your fault. You have to give me the $100,000. You want it to be very clear in that redevelopment agreement that the the developer and the developer alone is responsible for that shortfall. It's important as a financial matter, but it's important as a city also to your constituents and to protect the constituents. And again, frankly, to respond to some of the criticisms of TIF that cities are somehow taking risk with taxpayer dollars that a developer should be taking. If your redevelopment agreement provides very clearly that the developer is responsible for any shortfall, then the city is not taking that risk and the taxpayers are not taking that risk. So very, very important point. The redevelopment agreement is really a critical, maybe the most critical part of any TIF project or TIF implementation of TIF. Everything is important, of course, and needs to comply with the statutes, but the redevelopment agreement is really the thing that lives on and really governs at the closest level that transaction. One more point on the redevelopment agreement. Even if it's a project where the city is the developer and the city is expending the TIF revenues, it is still good practice to have some kind of an agreement. You might not have an agreement between the city and itself, right? You should have two arm's length parties to an agreement, but you might have the city council, for example, or the CRA or CDA adopt a resolution that sets out the understandings of what exactly is going to happen with those TIF revenues, how those TIF revenues are going to flow, what happens if those TIF revenues are not sufficient, and all of those kinds of things. Let me stop there. I know that's a lot. Anybody have any questions or anything at this point? Okay, let's go to the next slide. Thank you. So one of the questions was about micro TIF. You can see there it came about in 2020. Senator Mike Groney from North Platte, who had been an opponent of TIF, actually came up with and sponsored LB 1021, which became what came to be known as micro TIF. And it provides for expedited review of smaller projects to repair, rehabilitate, or replace an existing structure within a substandard or blighted area. So you can see there, again, I mentioned kind of the three stages of a TIF project. The area still has to be substandard and blighted. The statute said before, and it still says after LB 1021, that to adopt a redevelopment plan and to divide taxes in an area, that area needs to have been properly designated as blighted and substandard. And that holds true with micro TIF as well. Kelly, next slide, please. Thank you. So good thing everybody's looking at their computers. If this were on a screen, this would be too small of text for a slide. But so to qualify for expedited review, the project has to be either in a county with less than 100,000 inhabitants or an area that's been declared extremely blighted. Omaha did not want to be part of micro TIF because the number of applications that could come in would have been very difficult to deal with. The existing structure has to be repaired, or to be repaired, rehabilitated, or replaced must be at least 60 years old. And as you can see here, there are some dollar amounts, although they're not all that small, that limit the size of a TIF project based on these dollar amounts. Now, these dollar amounts are the cost of the project in total. This isn't the amount of TIF or the estimated incremental tax revenues, but this is the amount of money that's going to be spent. These are maximum amounts of money that could be spent on a project that qualifies potentially for micro TIF. Next slide, please. So micro TIF, the whole point was really to expedite the review. Senator Groney, I think, had a feeling or a thought, a belief, mistaken or not, that TIF is only available to big developers in large cities. And so wanted to create something that was expedited that could be used kind of by the everyday person on smaller projects. So there's supposed to be a standard application form. It's supposed to be very easy. You shouldn't need to hire an attorney to go through this process in theory. This form is submitted in lieu of the typical redevelopment plan, which often is prepared by a consultant and an attorney perhaps. So this is a much simpler process in theory, must be submitted directly to the governing body of the municipality. Redevelopers must also obtain necessary building permits prior to submitting their TIF application. If the standard form necessary permits and the fee are properly submitted and those documents satisfy the requirements, the governing body must approve the project. So the goal here is to take the discretion, and perhaps the thought was the politics out of TIF projects, take it out of the hands of a city council or a planning commission or a CDA or a CRA, and turn this in from a discretionary approval to a ministerial approval. The jurisdiction must approve the project. In this case, the project would be the authorization of dividing taxes and providing the revenues from those divided taxes if the applicant has met the necessary requirements. Next slide, please. So micro TIF is for 10 years or less. As I mentioned before, typically TIF projects are for 15 years and in some cases 20 years. Micro TIF is a 10-year TIF. So that's a significant reduction in benefit from a 15 or a 20-year TIF. And so something to think seriously about before deciding to use micro TIF if it's available in that jurisdiction versus going through the rest of the process. You think about that, each one of those years is another year of revenues, incremental tax revenues that could go to finance indebtedness, that secured money that was originally spent toward infrastructure benefiting the project. So in 10 years, you're going to get less, well, 50% less than in 15 years. And I think we have something in the chat, maybe from Christy, and I think maybe she's right that the law then changed to allow micro TIF for 15 years. And I think she's right. So thank you for that correction. I think we did these slides after the first go around. You can see their projects are to be completed within 2 years, and a project is complete after certification by the county assessor. Kind of an odd place or an odd office to have certification. You'd think the assessor, the building department or the planning department would be a place that would have better knowledge if something is complete. And then payments go directly to the property owner. So you don't have that financing part that I talked about before with the bond or the note. Cities must provide certain information about the expedited projects in the annual report to the property tax administrator. That report to the property tax administrator is a fairly new requirement, and that's an important thing to be aware of as well. So the next slide is on 20-year TIF. Before we go to that, one other thing I wanted to mention about micro TIF. I advocated during the process of approving micro TIF in the legislature, and I was not successful. So that's fine. That certainly happens, and it happens for lots of reasons. But I advocated that a way to really expedite micro TIF or to expedite TIF would be for the city to prepare or set the set the table for the use of micro-TIF by adopting a redevelopment plan that provided for the use of micro-TIF. And that's also a way for the city, if they think micro-TIF is a good idea, let's say maybe in a neighborhood, but not downtown, to guide the use of micro-TIF rather than just saying, we'll use micro-TIF or we won't. The city, through the adoption of a redevelopment plan, again, which is kind of a preemptive thing, it's a predicate for the use of TIF, can guide the use of micro-TIF. It also saves the applicant significant time and significant work. One of the things that's required is to provide a redevelopment plan or a plan for the use of the micro-TIF. If the city has already adopted a redevelopment plan that allows for and guides the use of micro-TIF, to me, that's truly expediting the process and the city working together with applicants to guide the use of micro-TIF and to use micro-TIF in the way. I think that Senator Groney it intended in a truly an expedited fashion. There was definitely some resistance to micro-TIF, and cities were concerned for a variety of reasons that are very understandable. I think there's some benefits to it, but I think if a city is going to take on micro-TIF, it should do so in a guided and thoughtful way. And to me, a very good way to do that is through the use of a redevelopment plan that anticipates and guides and directs the use of micro-TIF. So moving on then, and I'm trying to hit some topics here that are new, rather than sort of giving a more detailed overview of TIF than I did in the first session. And so it's a little bit of a smorgasbord, and certainly, again, please feel free to jump in with any questions. So 20-year TIF is a new thing. Senator Justin Wayne from Omaha led the charge for 20-year TIF. As I mentioned before, in the Constitution, the division of taxes was only allowed to go on for 15 years. And even 5 more years of being able to divide those taxes and use those revenues, especially on a large project, can be very significant. So 20-year TIF was first adopted in the legislature as constitutional, as LB 25 and Constitutional Amendment 14CA. And then it went to a vote of the people and passed overwhelmingly. I don't remember what the numbers were. It's kind of interesting in the world of legislation and elections and constitutional amendments. People had talked about 20-year TIF for a long time, and there was nobody really took it on because we all knew and that you'd have to have it passed at the ballot box, and we all thought you'd have to run a campaign to do that, and that would be very expensive, and nobody ever kind of said, all right, I'll pay for that, or I'll pass the hat. And so it never happened. And then it went on the ballot, and there was not much of a campaign for it, and it passed overwhelmingly. So I guess you don't know what you don't know. The critical thing in this slide, frankly, doesn't do a great job of explaining it or putting it forward, but the critical thing to allow 20-year TIF is that the area in which the 20-year division of taxes may be allowed instead of the 15-year division of taxes is that area must be designated extremely blighted and substandard, not just blighted and substandard. And I won't go through all the metrics, but essentially extremely blighted has higher thresholds for things like income, unemployment levels, things like that. So an area that is blighted and substandard, an area that is extremely blighted and substandard, sort of by definition, is blighted and substandard. But then the blighted part of that definition in particular meets higher thresholds. And that must be for at least 50% of the project area deriving the TIF. Certain cities, Omaha is an example, have gone ahead on their own and designated areas that qualify as extremely blighted. Lincoln has done that, and I think is in the process of doing more of that, as a way to prime the pump and create the conditions that are most ripe as possible for economic development. Do that step ahead of time so that developers will see that as a benefit. It's a cost and an expense and a risk, and an expenditure of time then that the developer does not have to expend. The developer knows the rules coming in, and the rules are already set. Um, and that's good in helping and attracting development. There has been some debate, to put it mildly, on how some cities have used the extreme blight designation and 20-year TIF. Senator Wayne has made it very clear that it was his intention that 15-year TIF or TIF generally in the state didn't just sort of all of a sudden become 20-year TIF instead of 15-year TIF, but that if a city is going to allow the division of taxes for 20 years, that it be really an extraordinary case or a special case, something especially worthy of allowing the division of taxes. And so as the last bullet on this slide says, how to utilize or implement the extreme blight designation and the opportunity perhaps for 20-year TIF is really up to a municipality's discretion. But we strongly advise that you have your city council or your CDA or your CRA or all of the above adopt a formal written policy that says any project that is seeking to divide taxes for 20 years must meet one or more of these criteria, or have one or more of these qualities. And those qualities and criteria tend to be things like affordable housing, workforce housing, significant job creation or job preservation, significant business attraction and retention, rehabilitation of significant historic resources, things that are on the National Register, for example, things with significant environmental or sustainability benefits is one. I believe Lincoln may have that in its policy, for example. And so you want to have those written and formally adopted so that there's no argument when a developer comes forward and says, well, I know the mayor, I can get 20-year TIF for my run-of-the-mill market rate apartment project. You want to avoid that discussion altogether. And I think the things that I listed just now that are things that in policies like this that cities have adopted with which I'm familiar, I think those meet the intent and the spirit of the law. One project that I was fortunate enough to work on this year that is using 20-year TIF is the City of Omaha streetcar. And there was certainly some debate over whether that's an appropriate project for dividing taxes for 20 years. The argument for that is that it is projected to spur and support significant economic development and growth to the tune of $4 to $5 billion over the next 20 years. It is expected to create opportunities for more affordable housing by allowing people to live with fewer cars or no car at all, and be proximate to a job and shopping and retail and fun and recreation and all of those things. And that it's an incredibly significant investment, long-term investment in the future of the urban core of the city of Omaha. All of those things, in my view, and this is the case that was made, represent an appropriate use of the division of taxes for 20 years. It is certainly not a run-of-the-mill project of any way, shape, or form. But even a project like that did draw some scrutiny in and for its use of dividing taxes for 20 years instead of 15. And of course, this may be obvious, but when you divide taxes for longer, it's more money to the project, it's more incremental tax revenues to the project, but it is a longer period of time where the school district and the other taxing entities are not receiving, at least directly, the benefit of that investment that created those incremental taxes in the first place. Now they may be receiving immediate benefit of sort of spin-off projects or projects that the original project helped encourage that did not use TIF, but it is a longer time during which those incremental revenues don't go to those taxing entities. Those original revenues, of course, do, but the incremental revenues don't. Any questions there before I go on to the next topic that I thought might be of interest? Okay, you guys are not going to help me out today. All right, I'm on my own. That's okay. So I wanted to talk about enhanced employment areas a little bit. I don't know how many communities have used these. I don't think there are a lot of them across the state. This is also a fairly new tool, not as new as micro TIF or 20-year TIF, but this is probably 10 years old, 8 years old, something like that, somewhere in that neighborhood. An enhanced employment area, let me kind of cut to the end and then I'll come back and go through some of the details, is a way to use TIF, use the community development law, but it involves sales tax instead of property tax. And so, and it's flexible. It can be used in a blighted and substandard area. It can also be used outside of a blighted and substandard area. So an enhanced employment area, in effect, sales tax TIF instead of property tax TIF, is an interesting tool. People also like it because it occurs within a district typically, and because it's a sales tax, it is effectively imposed upon the users of that district. Now, regular TIF is also imposed on the user, if you will, because it's that developer, that property owner who pays those property taxes. But the delay in those incremental revenues going to the school districts, for example, is an externality that occurs with regular TIF, whereas an enhanced employment area, essentially it's an additional sales tax within an area designated, as I'll walk through here in a second, under the community development law. The results again in a revenue stream that pays off a bond or a note or a loan, some kind of financial instrument, and the proceeds from that financial instrument are used to construct infrastructure. Although with an enhanced employment area outside of a blighted and substandard area, there is arguably a broader list of things that are eligible expenses in the statute, including things like services, landscaping, security, things like that you can use enhanced employment area revenues for outside of a blighted and substandard area that you cannot use them for inside of a blighted and substandard area, or that you could not use TIF revenues for. TIF revenues cannot be used for services, for example, or things that are not improvements to real property. And so you want to be aware of that. So an enhanced employment area is something that the governing body designates. Again, this is a city council action. If within a blighted and substandard area, the project is included as part of the redevelopment plan in a similar manner to TIF. And as the note, as I talked about, it covers expenses similar to TIF. Outside of a blighted and substandard area, then the developer enters into a standalone redevelopment agreement. In either case, you want to have a redevelopment agreement, just like with typical tax increment financing. That says essentially, okay, we're going to provide these revenues, and developer, here are the things that you're going to do with these revenues. The sales tax percentage. Well, let me finish this slide. To designate an EA, the developer must commit a certain amount of funds. So there's a minimum cost of the project, and there's a minimum number of jobs that the project must create to qualify for the use of an enhanced employment area. You'll let's go to the next slide, please, Kelly. You'll hear an enhanced employment area called an EEA. You'll also hear it referred to as a GBOT, which stands for General Business Occupation Tax. The GBOT, or the tax, is the result of designating the EEA. Let me talk about the EEA a little bit, and kind of some policy thoughts about this. These are my opinions as to best practices. They're not necessarily what the statute limits or requires, but I think they're good practice, or at least good things to think about if you're going to use an EEA and a GBOT. In Omaha, for example, there are EEAs. There are a number of them. I don't know, maybe 5 or 6. One of them, 2 of them at least, that we worked on involve single buildings. They're large mixed-use downtown buildings, but they are single buildings. Others of them involve what you would view typically as a district, the Blackstone district, for example. The ones that are buildings are large enough and are mixed use that, in a sense, they constitute a vertical district, but a single building, unless it's awfully large, is going to be fundamentally different than a neighborhood business district, for example, like the Blackstone district, or the Capitol district is another example of an EEA. In my view, it makes a lot of sense for the city to really drive the use of an EEA. You need the buy-in from the property owners, because they're the ones who are going to subject their users to the tax. And it needs to be an area that is a heavily business area, right? That has taxable sales. You don't want to put an EEA in a residential area without taxable sales. But if you have a district that is an area with a lot of retail sales, so stores, bars, restaurants, parking garages, hotels are some of the examples where you can put the additional tax and the property owners will buy in. It's a way for the city to designate the sales tax generated in those areas for improvements in those areas. And those improvements often are area-wide improvements. For example, a single parking garage, or a major public improvement, a green space, or a pedestrian amenity, something like that, that really benefits the whole district. I see an EEA as a real policy tool, and again, a way to drive and guide economic development for a city. And I think it's a little bit different potentially than typical TIF in that regard, where you have a building or a project that is going to create increment. And so I think it's wise to use an EEA, or at least look at an EEA in a bit of a holistic sense. And if a developer or a group of property owners comes forth and wants to use this tool, to look at it in that way, rather than just in the kind of narrow lens of their project or their property or their proposal. I think I've probably said what's on this slide, but once the governing body designates the EEA, and again, the EEA must qualify in terms of jobs and money spent on the projects that will generate the increment. The governing body may levy the general business occupation tax against the businesses within that area to pay for certain project costs. Again, those project costs are the typical public improvements or improvements of public benefit that go with the TIF project. The city and the developer may choose what types of items or businesses are taxed. The tax must be uniform across those areas, so you can't tax one restaurant 1% and another restaurant 2%, without those restaurants maybe being fast food and sit down or some discernible category. Where the city and the developer come together to do that taxing, to designate and levy those tax, is in an ordinance. So the city council will pass an ordinance that says we're going to levy a general business occupation tax under these sections of the community development law, and we're going to levy that tax for some period of time. Because this is sales tax and not property tax, it does not have that constitutional limit of the 15 years or 20 years. And so there's a reference in the EEA portion of the community development law to a 20-year bond. Some practitioners think, therefore, that means the maximum time for a GBOT in an EEA is 20 years. Others don't feel that way. The longest I've seen these go is 25 years. And so in that ordinance, the city council ultimately will ordain, okay, we are going to impose this tax pursuant to this authority that we receive from the community development law from the legislature, authorizes us as a city to do this. We're going to levy this tax for 25 years, and we're going to tax off-street parking 5%. We're going to tax food and beverage 2%. We're going to tax hotel rooms 3%. And we're going to tax general retail sales 1%, or whatever it might be. It really is within the discretion of the city and the developer. Developer's argument is, hey, look, I'm taxing my own customers. Whatever I think that the market will bear, I ought to be able to tax them. You get a different view of that sometimes from elected officials. We have one elected official in Omaha in the city council who I think has voted no on every EEA and GBOT. Thank you, Kelly, for the 10-minute warning. She's fully supportive of development and redevelopment in TIF, but she sees this additional sales tax as an additional sales tax, where again a developer will say, well, look, I'm taxing my own customers, or a group of businesses in an area will say, look, we're taxing our own customers, and so, you know, kind of leave us alone and let us do what we want to do, and we're using these revenues to pay for public benefits anyway. And those things come down differently. I think everybody's got a valid point there, but I just wanted to point out some of the kind of policy argument there. I've got a whole bunch of slides left, kind of some TIF 101 and governance and more of the nuts and bolts of TIF. I'm not going to go through those just because we're down to about 7 minutes here, at least by my clock. I have one other thing that I think is just kind of interesting with regard to the community development law that I'll share here. But before I do that, does anybody have any questions or comments about anything that I've said so far? No takers. Okay. So
Dave, a question
yeah,
for you.
please. Yeah.
How involved, as an attorney, how involved are you throughout the setup of the substandard and blight study, the redevelopment plan, setting up, tax increment financing to the actual development of a project?
Great question. Thank you for that. And it depends. We at least represent or work on TIF projects both on the side of the developer, particularly in Lincoln and Omaha and other cities that have city attorneys and city attorney offices. They're very, very well versed in the community development law, and they represent the city. We also represent numerous cities as special TIF counsel, where in those cases, those city attorneys have said, I don't have the bandwidth or the desire or whatever it might be to deal with TIF as well. And I think we ought to have outside counsel. From the developer standpoint, we are involved from the beginning typically. You help put together the application, working with the developer and especially their financial team to make sure that it meets the city's requirements and is defensible, and you can argue it. We're involved in sort of lobbying the city and the planning department and the city council and explaining to them what it is we're asking for and why they should allow it. The city itself probably has done or will largely do the blight study, but the developers council, I think, can provide important input there. It shouldn't be an us versus them thing. It should be collaborative in my book. Why not? Doesn't mean the city has to do what the developer's attorney says, but if that person's knowledgeable, I see no harm in having their input. And same thing with the redevelopment plan. A redevelopment plan or a redevelopment plan amendment is probably pretty project specific. And so that's another thing where a developer's attorney will be involved. And then a developer's attorney will be very involved in negotiating and drafting the redevelopment agreement. Typically, and again, in my view, ideally, that's a collaborative process. When we are representing cities as TIF counsel, this may be self-serving, but my view is that it's good to involve the attorneys early on to help kind of plan and chart the course. And okay, this is the area that we're going to designate as blighted and substandard, and here's why. This is the area that the redevelopment plan is going to cover. You want to have the attorney review the redevelopment plan, I think, to make sure that it checks all the statutory boxes, and then have the attorney present typically at the hearings of the Planning Commission, the CDA or CRA, and the City Council. And then certainly the city's attorney is going to be very involved in preparing that redevelopment agreement and representing the city in the negotiation and preparation of that agreement. So for better or for worse, a lot of attorney involvement, but a little bit different, I think, on the city side. The blight and substandard part of it is probably the area either city's attorney or developer's attorney of kind of least involvement. The redevelopment agreement is the part of it with most involvement. Redevelopment plan probably in the middle. And then, the application probably has some attorney review on it as well, but that varies from city to city. So with that, it's 12:58. Any last questions or anything else? All right. I think we'll leave it there. Thank you all very much. I saw that Kelly said that she will share the slides. There's a number of them in there, like I said, that I didn't get to. If you have any questions about any of this, I think the very last slide is my contact information. Don't ever hesitate to reach out. And again, thank you for the opportunity.
Thank you, David. I appreciate you taking time this afternoon to share your perspective on tax increment financing. His contact information is available here. If your communities do have direct questions that maybe your city attorney or village attorney hasn't been able to answer, please feel free to reach out to him. Our next TIF event, the last one of the series, is next Wednesday, October 5th. That is the Community Economic Development Perspective, where we're having Tobias Templemeyer kind of share his thoughts on the success that Beatrice has had using TIF. So I want to thank you all for attending this afternoon. I hope you have a great rest of your afternoon, and hopefully we'll see you next week.
Thanks all.
Thanks, David, again.
Thank you all. Take good care.